Good evening. We begin tonight with the shooting of Ricky Cobb II early Monday morning on I-94 in Minneapolis when a state trooper shot him as those troopers were trying to get him out of his car. But today, 2 days later, still a lot of questions about what happened. Like, why exactly were those state troopers trying to take him into custody if Mr. Cobb didn't have a warrant? Lou has been on this case since the start. He's on the show tonight. Hi, Lou.
Hi, Jana. We set out to answer questions about what the State Patrol was attempting to do and why prior to the use of deadly force, as well as which questions will need to be addressed in determining whether the use of force was legally justified.
Yeah, like I said, they want him hooked up and brought down. So
the first thing the Minnesota State Troopers are heard discussing on the body camera video is that the Ramsey County Sheriff's Office wants them to arrest Ricky Cobb. Police reports and court records show Cobb had an active order for protection against him in Ramsey County from the mother of 2 of his children, and he was on supervised probation in Anoka County for domestic abuse. Troopers approached to attempt what's called a probable cause hold or pickup for violating the domestic abuse order for protection.
And they can do that, such as they were trying to do in this case?
Yes, virtually anywhere, in particular on a public road. There's no obstacle for them to make an arrest in a public setting like that.
Paul Applebaum is an attorney on the criminal and civil sides who's both represented police and sued police. He says the way the state troopers conducted themselves prior to the use of force appears to be legal.
Would it be normal for officers to open a car door or try to unbuckle somebody's seatbelt to arrest them if they're in a car like that?
For an arrest, absolutely. That sort of probable cause to arrest is what gives them the authority to open the door to take this person into custody using reasonable force to do so.
But Applebaum says the use of force itself will be highly debated. The situation escalated when Cobb put the car into drive and the trooper closest to him reached into his car, appearing to try to unbuckle his seatbelt while the trooper on the passenger side pulled his gun.
You can't choose where your partners are when you determine that you're going to use your gun. But what you can determine is whether you're going to pull the trigger.
Questions that come to mind for Applebaum are, was it an overreaction to pull the gun? Was it necessary to fire? And was it reckless to shoot with his partner so close? At the same time, Applebaum points out it all happens in a matter of seconds. The driver's side trooper is dangling from the moving car, and we have the benefit of hindsight when dissecting it frame by frame.
Is this a hard case?
So there are very strong counterbalancing factors in this case, so it's tough.
And the ultimate question in Minnesota when it comes to the use of deadly force is whether an objectively reasonable officer would believe the person posed a threat of death or great bodily harm to the officer or to another.
And that part about to another, that officer could use as a defense, he thought his partner was in trouble?
Yeah, and to be clear, we have not heard what his reason was for shooting from his perspective, but if it was, for example, that he thought his partner was at risk of death or great bodily harm, then it could be perceived as a legal use of deadly force.
And as you've previously reported, will charging decisions come from the Hennepin County attorney? We're just not at that point yet.
Yes, that's Hennepin County Mary Moriarty. She's waiting until after the BCA finishes its investigation. The BCA says typically that takes about 60 days. She has asked them to prioritize that one, so it could be a little sooner than that, but we'll see.
Okay, thanks so much, Lou. Appreciate it.